and want to welcome you to Library Law from A to Z. This is a programs on why libraries should have their own attorneys. It's the second in our two-part program, sponsored by both the Buckles Trustee Development Committee. I am Tom Madrew, and I'm co-chair of that committee. And it's also co-sponsored by the Buckles Library Administration Management and Personnel Committee, who does approximately the same thing we do for trees, they do for directors. We're very happy that we have a guest speaker tonight. Donald Zucker is with us. He is a partner with the Weiner Law Group, LLP law firm, and he will lead us in this program tonight. If you do have a few administration things, first of all, please, everybody, remain on mute. And if you have any questions, please put them in the chat box. A couple of folks will be monitoring that. Then we will get to those within the program. So thank you very much. And without further ado, I'd like to turn it over to Douglas Zucker, who will lead us through this program. Thank you very much.
Thank you very much, Tom. And good evening, everybody. We have an hour and a half. I'll try my best to keep it interesting. But I look forward to questions because questions are good. Although I was given a bunch of questions in advance that people submitted, and so we'll go through those and cover anything else that comes up. To tell you just a little bit about myself, I am primarily a labor and employment lawyer. That's what I've done my entire career, representing employers in all aspects of the employer-employee relationship. That could be unionized employers, non-union employers, public as well as private sector employers. That evolved, or that led me to start representing public libraries. Currently, I represent 24 municipal libraries and 2 county library systems spanning throughout the state. Goes into Bergen County, down into Ocean County, and out to Warren County, and a lot of places in between. I feel very honored and blessed to be able to represent so many libraries and to be able to do so much of it, because I really love libraries and love working with libraries. I think public libraries are underappreciated. I think most people, unless they actively use their library, don't appreciate what libraries do and the diversity of things that they provide, the services they provide in terms of programming, whether it's for kids or for teens or for seniors or for anybody in between. Whether it's borrowing not only books and magazines and movies and music and in hard copy or electronic, but they could borrow museum passes and go to museums for free. They could go to the Library of Things, and they could get a power washer, or they could get a fishing pole, or they could get almost anything that happens to be in that Library of Things because they're borrowing things. Or they could go to a library of seeds and get all kinds of different seeds. Those they don't have to return. That's one thing. But they plant the seeds and then they can grow things, all courtesy of their public library. It's really quite extraordinary, the diversity. And for me, it's really an amazement when I see how many creative things librarians and library staff think to add to their programs. And I shouldn't only say that, it's also the trustees, I'm sure, give input as well. And it's also rewarding to see the outreach that you're doing to the local communities and what they're providing, not just within the 4 walls of the library, but beyond the 4 walls and into the outer community. Libraries are also bastions of First Amendment rights and protecting First Amendment rights. And so I find myself working very much at the forefront of that because I deal with it all the time. Indeed, a lot of times when I tell people that I represent public libraries, they say, why does the public library need an attorney? So I'm going to get into it in more detail, but I was just thinking, I made a list of the different things I've done for my library clients this week. This is just some of the stuff where I got questions or had other work to do. We talked about patron misconduct issues. We talked about patron complaint issues. By the way, these are a lot of different libraries. It's not just one library with all of these issues at the same time. There were patient requests for things that led to confidentiality, talking about confidentiality of library records, background checks for teen volunteers, preparation of requests for proposals, RFPs, which is the whole public contracting issues, employee discipline issues for 3 or 4 different types of issues. They're not the same issues. Medical leave of absence and return to work issues, reasonable accommodation, a lot of stuff on financing, whether it's negotiating between the library and the municipality, or whether it's protecting the library from the municipality, or how to expand capital accounts and how to put money into a capital account. I dealt with issues related to dissension among board members and how do you deal with dissension of board members and trying to bring them closer together. Negotiation of union contracts. Reviewing reviewing a contract with an outside vendor. Looking at library grant documents. Helping recruit for a new library director, as well as what to do about an interim director. Dealing with Open Public Meetings Act questions about about the agenda. When are you allowed to go into executive session? Rights notices for employees who are being discussed at a meeting. Porn in libraries, pornography in libraries. A question, an issue I'm dealing with about a municipal library considering joining a county library system. And I attended 2 board of trustees meetings. And it's only Thursday. And this is just this week. So it has been a very busy week, I grant you, but it just shows you the diversity and variety of things that I get to do as a library attorney. And for me, it makes it really interesting and exciting. And hopefully you'll think so as well. We broke the questions that we received down into categories and groupings, and I'll go through them. And again, if there's anything I say that somebody doesn't understand, just please put the question into the chat and they'll let me know and we will try to cover it. The basic question that we start with is, what is a library law attorney and how does that differ from somebody who's like a general counsel, I guess, general counsel for a municipality or otherwise? Well, I just mentioned a bunch of the different kinds of things that I do, but note that there is a specific body of law that's library law. There are statutes in New Jersey that talk about formation of libraries, talk about what the construction of a board of trustees, how many trustees, the powers of the board of trustees, what they can do and what they can't do, how boards or libraries are financed, the third of the mill, based on property values. What happens with the money? Who holds it? Who controls it? How is it allowed to be spent? There's specific regulations that discuss what are permissible expenses for public libraries from that third of the mill, and whether we're talking about expenses for capital needs or operational needs, there are lists. So there's certain things that are not permitted. I'm dealing with an issue with one library involving a parking lot, and it's not the only time this has come up. It's come up in other places, and whether it's plowing the parking lot or paving the parking lot, who owns the parking lot? It's my position that the municipality owns the parking lot, because all land, the library building is owned by the municipality by statute. The law says that title to all buildings rests with the municipality. I think the reason for that, and this isn't official, this is my own opinion, is just that if something should ever happen and the library ceases to exist or closes, what would you do with the building otherwise? If the municipality is always going to be there, so if the property has to revert, it'll revert back to the town or the borough or the city. Excuse me. There are other provisions of the law that talk about confidentiality of library records and what libraries are allowed to do and what they're not allowed to do and are allowed to disclose. There's statutory provisions. Well, there's also other bodies of law that are related to it, but not necessarily directly on point. For example, First Amendment. There's a lot we'll talk in the latter part of the presentation tonight about First Amendment audits and free speech things, but you have to become familiar, and I've become very familiar with the First Amendment and what it means and the implications for libraries as a result of representing libraries. And I think to be a library attorney, you really need to have that diversity. I think you also need to know a lot about labor and employment law, because in most cases, and for most of my libraries, I am the attorney. And so whether it's a labor issue or it's a general library issue or a public contracting issue, you need to know about everything, but they're all interrelated. I don't know how many people are repeating from 2 weeks ago. So if I say something we said previously, I apologize. I'll try to minimize that. But one example that came to mind was a situation that started as an issue about construction, and so there are all these public contracting issues that came up that we had to deal with. And then there was a remediation issue because in the course of doing things, they realized that there was asbestos. So we had to worry about remediation and dealing with asbestos. So that brings in a whole other body of law under OSHA, the Occupational Safety and Health Act. And then, of course, you have employees, and the employees are concerned about exposure to the asbestos. So that brings in other personnel or labor-related issues. And then some of those employees are going to claim workers' comp. So that's another body of law. Some are going to claim issues related just to a medical leave of absence, or maybe a need for reasonable accommodation. So here now you have the Americans with Disabilities Act, and you have the Family and Medical Leave Act. So there's a lot of different pieces going on. And if there's a union involved there, then you have issues of negotiating with the union about the impact of the asbestos and any claims that it in fact impacted anyone. Excuse me. There's also it's also important for a library attorney, excuse me, I'm sorry, to understand the difference between municipal law and library law. I don't represent municipalities, so I don't pretend to be an expert on municipal law, but I do know where there's differences. Funding is different, control of money is different. I don't think we'll have any questions about that, so I'll talk about that just a little bit. Libraries are funded by statute, as I said, a third of the mill. It creates a specific library tax, which is a dedicated appropriation from the municipal budget. The statute says that a municipality, once the money is collected by the municipality, the law says they turn over the money to the library board through the treasurer. But it also allows for the fact that the money could be held by the municipality, and the municipality either could distribute to the library in quarters as they collect it, or that the municipality could hold most of the funds and just write the checks for the library. That's the most common structure that exists in all but a small number of libraries. I expect in most of your libraries, the system is that the request for payment comes from the library, but the actual checks are written by the municipality. That's perfectly permissible. But what I've seen in many cases is that the town council has to approve the library invoices before they're paid. But that's not what the law says. The law just says that the municipality pays based on payments approved by the library board of trustees. This is not going to be good if I lose my voice. So the law says only what's paid, only what's approved by the library board of trustees. But then the practical side is, if your bills are getting paid, are you going to fight the city council because they want to approve everything? where issues arise is when the town does not want to approve something. Many times it's not even the town council, and I'm saying town, but it's borough or city or whatever. It's not the governing body like the town council that's the issue, but it could be the CFO for the town or the business administrator for the town, and they're creating an obstacle for one reason or another. And sometimes it's simply because they don't understand the law and how it's supposed to work. I find that I spend a lot of my time educating municipal attorneys about library law and how libraries are different than municipalities and why the whole financial structure is different, and that libraries are not subject to all of the same requirements that a municipality is required to follow. They usually don't understand that, and I've had to write letters about it to them and have meetings and explain it to them. They often don't like it, but you usually can educate them and bring them along. One big area of conflict has arisen, and I'm sure many of your libraries are experiencing this, where the municipality says, well, you have a budget of X and you're not spending all of that money. And so why should we be spending money for whatever, a new roof, a new HVAC system, paving the parking lot, or whatever it may be? The library has money in a capital account. You should use your money, even if it's not an appropriate expense, and even though the benefit ultimately will remain with the town because it's an improvement. I apologize for my voice. I didn't know this was going to happen. Having an attorney who understands the differences and has an understanding of library law, I believe, is very important, because it just helps to be able to address and answer the attacks or the statements made by someone from municipal government, and to defend and advocate on behalf of the library. Somebody who doesn't understand those nuances is not going to be in a position to do it. There's a question that came up later, but I'll address now, about whether library attorneys should be involved in reviewing of policies. My view is yes. You don't have to necessarily have the attorney write it. I usually suggest that my clients draft it and I'll edit it for them. But it's important because there are issues that come up that, unless you have a background in libraries, you're not going to know how best to draft it. One, you have to have an understanding how libraries operate, what the difference is in terms of the system, in terms of the structure, in terms of the time, and when libraries are open, the fact that you're open 6 or 7 days in many cases, evenings and days, different scheduling than the municipal government usually operates. It's understanding for collection development, what a collection development policy looks like and what it should include. It's something that's unique to libraries. No other business that I'm aware of or government entity has something like a collection development. Patron conduct policies, controlling and monitoring what patrons can and can't do, and monitoring their behavior and giving direction to it, is different in a public library than it is in most other places. It's going to tie into a lot of the First Amendment stuff that we'll talk about near the end, but it's a unique nuance. And so unless the library attorney has an understanding of library law, the operational policies, at least, it would be very difficult to have them evaluated. There are also employment policies that you'll have, personnel policies, and then as long as the individual has a background in labor and employment law, probably those policies can be reviewed by just a labor and employment lawyer. But again, my view is if you can find somebody who does both, it's better because then you only have one lawyer and then everything is also integrated. The focus of the program initially was supposed to be, or overall focus is, does the library need to have its own attorney? Everybody who I know, and I'm talking about library directors, when we talked about the topic, they said, well, of course they do. That's an easy one. And indeed, I strongly agree with that. And not only, it's not just me, but there is something put out by the state library called the Manual for Trustees that many of you probably have seen. And in one section of it, section 4.2, I think, it specifically says, to avoid conflict of interest, the board should retain an attorney that does not represent the municipality or county. So when somebody asks, we just rely on the municipal attorney for our attorney, is that okay? My view is that's a really bad idea. I'll give you some examples of how it turns out, but I'll also then give you some background in the law as to legally why I think it's not appropriate. I had one of the libraries, they first brought me in because they always had their union contract negotiated by the town. And although the contract was a separate contract for the library employees, it was all negotiated together. Well, the town had an issue with the DPW employees. The portion of the contract that related to the librarians or library staff, that was resolved. It took another year to get the DPW part of the contract resolved because that, I don't even know what the issue was, but there was some big issue that was holding things up. So the library staff couldn't get their raises for a year, having nothing to do with them. It's strictly to do with the fact that this unrelated bargaining unit had a conflict and wasn't able to get the contract done. And the town wouldn't sign separately. They said it's all or nothing. I think as a way to put pressure, because it was the same union representing everybody. That library board said, we need our own attorney because we don't want to compromise our staff. It created a lot of morale issues with the staff because they had to wait for a raise when there was nothing they could do. It was totally beyond their control. I had another issue in terms of conflict where it was a small library in a small borough, but the town decided that really it's the CFO in that case who decided that a way to get more money for the budget of the municipality, for the borough, was to start charging the library for plowing their parking lot and for any kind of work that DPW was doing for it, and for processing their payroll, even though they had processed their payroll for years and the number of library employees did not significantly increase the cost to the borough for doing it. I had to go then head to head with the municipal attorney and educate him in that case about why what they were doing was totally wrong and inappropriate. And ultimately, we met with the town council and they came around and things got resolved. But if I was also representing the municipality at the same time, I couldn't be on both sides of the argument. And quite honestly, the municipality is the bigger client than the library. And so if somebody's going to be on both sides of the issue, the municipality is going to win every time. That presents actually a direct conflict under the law because there's a code of ethics that lawyers have to follow called the Rules of Professional Responsibility. And what it says is, first, that an attorney who plenarily, meaning generally, represents a municipality is restricted relative to what else he or she can do. They can't represent other boards or agencies within the municipality. So you couldn't represent the municipality, say, and its zoning board or its planning board. And you clearly can't represent individuals adverse to the municipality. So you can't be representing the municipality and also be suing your own client. So then, in terms of labor council, there's a question of, well, is somebody considered representing the municipality generally if they're labor council, and there is an opinion that said, indeed, yes, they think that it is because it's a broad representation. So the feeling is you can't be representing the municipality under the rules of professional responsibility and also representing one of its boards, particularly a board that could be adverse to it, like the library board. One also notable difference is like a zoning board is part of the municipality. The library is independent because the library is run by the library board of trustees. It's not run by the municipality. Libraries sometimes are considered a department of a municipality, but it's not a department of a municipality. It's a separate entity with a separate budget, and the governing body is not the town council, it's the library board of trustees. There is a rule of ethics that says a lawyer employed by a public entity either shall not undertake representation of another client if the representation presents a substantial risk that the lawyer's responsibilities to the public entity, say to the town, would limit the lawyer's ability to provide independent advice or diligent and competent representation to either the public entity, so the town, or the client, i.e. the library board. So based on that rule, a library attorney should not be the municipal attorney because there's too many opportunities for conflicts to come up. Based on the money issues that I've mentioned a couple of times, increasingly what we're doing is negotiating what's called a shared services agreement. That means you set out in paper, which is your responsibility, what part is ours. The standard that we like to use, my clients usually say is, well, the board should be responsible for what's inside the library building and the town for what's outside the library building. So you care the structure of the building and the grounds around, but we'll do everything inside. But to have all of that sorted out and make sure that it's clear and to try to ensure that the library doesn't have to pay for any of it, you have what's called a shared services agreement. Well, that's a contract. If the contract has to be negotiated, how can the library negotiate a contract when their lawyer is the same lawyer who's on the other side of the contract? Logically, it just doesn't make any sense. So there's a whole expertise issue, but there's this whole issue of a legal conflict. And if a board is using the municipal attorney, there's no way a municipal attorney can give full representation to the library board and also give full representation to the municipality. Because I only represent library boards, I don't say I have a totally myopic view where I'm only looking at the library's perspective, but I'm only interested in the library's benefit and doing everything for the benefit of the library. So I can be consistent. There's a potential issue if somebody represents municipalities in one place and library boards in the other place, and some big issue comes up that attorney is arguing maybe publicly on behalf of a certain issue on one side of the issue, and that has a negative impact on libraries on the other side. Let's say it has something to do with funding and the structure of funding. The attorney say wins the big case on behalf of a municipal client, and that case should hold. This is not the law, but say it held that libraries are responsible for the property around the building and have to pay for their own property, maintaining all of that property. That would be bad for libraries. And so it would be a conflict because how can the same attorney advocate positively for a library when they're arguing against libraries? Okay. Another totally different kind of example, and it really touches on something later, but let me touch it now, where I've seen a conflict between being the library attorney and a municipal attorney, has to do with a policy on First Amendment audits. You know what? I'm sorry. I'm going to hold back on that. I'll have to explain First Amendment audit. I'm going to do that later on. So I'll come back to that. Sorry. Okay. There were some very specific procedural questions like, does a library attorney need to be selected or appointed each year? And is an RFP, a request for proposal, required? Requests for proposals are required for any public contracting that's sent out if it's over a certain level. The threshold is $17,500 for the value of the contract. But if the entity making the purchase, so if it's a town or if it's a library, has a qualified purchasing agent on staff, then the threshold goes up to 44,500, I believe, or at least 45,000. Very few libraries have a qualified purchasing agent, QPA, on their staff because the level of purchasing you're doing, you don't need it. There's also a lot of library materials is an exception to the law that doesn't require you go through public contracting. So, but for things like if you're going to do any kind of construction, if you're going to hire an architect, if you're going to hire a general contractor, if you're just going to do renovations and hiring any kind of contractor, for those kind of things, you need to issue a request for proposal, an RFP. The law has some exceptions when, regardless of the value of the contract, you don't have to issue an RFP. One of them, as I said, is for library materials. Another one is professional service contracts. So a professional service contract is a contract with somebody who's regarded as a professional. Attorneys fit that category. Auditors fit that category. Arguably, actually, I said architects. An architect might fit that category, although generally speaking, auditors are hired through a request for proposal. So does the library attorney need to be selected through a request for proposal? The answer is no, it's not. Some libraries do it anyway. Of the 26 libraries, I think maybe 5 of them have an RFP to which I have to respond each year or whenever it comes up. Some do it more informally where they just initially asked for a proposal, but it was not a full-blown RFP, which has all kinds of forms and documents that you have to complete as well. But other times I just got a call and I spoke to the director. They asked me about rates and about my experience, and then they hired me. Or sometimes I was interviewed by the board and they hired me. Point is, they didn't need to have RFPs. They could use it if they want, but they're not required to have an RFP to appoint or award a contract for an attorney. In terms of the term, professional service contracts can only be for 1-year terms. So in if you hire a library attorney, you'll hire him or award a contract for 1 year. When that year is up, you have to, even if you don't go out, even if the board is perfectly happy with that attorney and you just want to renew them, you can do that, but you have to pass a resolution. So if you, in January, it's a common time when you have your reorganization meeting, you appoint others, you can reappoint, the board can reappoint the attorney simply by passing a resolution. But you need to pass a resolution to reappoint, and that resolution has to then be published in your primary newspaper and every board has to have a primary newspaper, obviously. Okay. Now, question also asked about how are library attorneys compensated? Is there a retainer or a minimum number of hours billed each month? I know the way the way I do it, and the way other attorneys I've spoken to have done it, and that's always we just bill on an hourly basis. Very few libraries have such a need for legal services that you need to have a retainer where they're going to work a guaranteed number of hours every month. That could work in I guess in certain situations, but I haven't seen it. So the way I always do it is I just bill clients on an hourly basis or portion of an hour, based on what they need. Because for some of my libraries, I speak to them every week, and I'm doing work for them every week. But others, I speak to them when there's an issue, and sometimes an issue. So 1 month we may have a lot of activity to do, and then for 3 months I might not hear from them, or for 6 months I might not hear from them. Versus another one, 6 days don't go by when I don't hear from them. It's strictly a matter of it's the size of the library. It's sometimes things are just quiet, and I'm very lucky to represent a diversity of libraries. So, like I represent a county library system that's got 10 branch libraries and like 300 employees. But I also represent libraries that have 8 employees. There's going to be a whole lot less issue with the library with 8 employees, and less conflicts with the municipality with a library of 8 employees than with a library of 300. So billing on an hourly basis and paying your attorney on an hourly basis, I think makes the most sense. For budgeting purposes, there's an advantage to doing a retainer, but I don't know if a library that wanted to do it. I never had a library ask me to do that way, and it's not something I would particularly advocate. Somebody asked if I had any instances where a municipal attorney or the governing body interfered with me being hired by the library, even though the library is independent. I haven't seen them necessarily interfere or prohibit them from hiring a library attorney, but one, I've seen it where the town decided they wanted to be involved in the process, even though they have no role in the process. In other cases where the board had one attorney, and that attorney did everything, labor and the general counsel, general library legal work. And the town decided that no, you should split it, and you should have separate labor counsel from your municipal from your general library council. Why they wanted to do that, I don't know. They didn't say particularly, but maybe they wanted to have some control over who was awarded that contract. As a library attorney, I try to stay out of politics, out of the politics of things, and not get involved in those things. But some political appointments for work in municipalities could be political, and there may be some angle of politics. In another case where they have 2 separate attorneys, both the labor council and a general library council, the representative from the mayor on the board, because I'm sure you know that every board has 5 or 7 trustees, plus the mayor or the mayor's alternate, and the superintendent of schools or the alternate. Sometimes that mayor's alternate, or sometimes they're a council liaison, they're called, because it's still the same position. Sometimes that position takes a much more active role and more assertive role on the board, and sometimes less so. A lot of times it matters whether the person serving that role is actively serving as a member of the municipal council, or if they're just somebody else who the mayor appointed to serve. When it's somebody else the mayor appointed, that person usually is more committed to the board. When the person is a town council member or municipal council member who is also serving as the liaison, then they have a dual loyalty because they have responsibilities as the council person and they have responsibilities to the library board, and so it gets split. So in one instance, the mayor's representative, presumably coming through the mayor, insisted that the library appoint labor council who was the same labor council as the municipality. I looked at that, and for the reasons that I said earlier, I think that's a conflict of interest and it's not appropriate. But when the motto that I've lived by since I became an attorney is that I don't go into somebody else's house and make a mess. And what I mean by that is, before I was an attorney, I was a human resources manager, and we had an outside attorney, and he handled union negotiations for us. And he would say things during negotiations to our employees that created issues and problems. And sometimes the employees got very upset with the things that this attorney said. And then he would leave and go back to his office, and we were stuck cleaning up the mess that he created. It's not like he was advocating for a position that we wanted him to advocate, and then it came out badly. Sometimes the lawyer is the bad guy in negotiations, and that part's fine. But he would say things, try to be funny or trying to, I don't know what he was thinking, but it created real concern among some of the staff. And then again, he left and we had to clean up the mess. So that's why I live by the motto of don't go into somebody else's house and make a mess. So I have to be very conscious, and I think any attorney should be very conscious that although I have a certain viewpoint about the role between the library and the municipality, and I know what the law says, I'll tell you what the law says. But there's a practical side of things, and the practical side of things is that sometimes the structure is such that you can't change it. And if it's been going a certain way for many years, then they hire me and I say, no, this is all wrong. You got to do it this way, and creates a whole issue in the town. And it's not even a town in which I live. That's not really appropriate. I'll tell the board to explain to them what the issues are, but I always make sure that they recognize, and usually that they do ahead of time, that sometimes, even though it may not be strictly the proper way to do things, that's the way it goes. Like an example of that would be when I said earlier about the town council has no need and no legal basis to have to approve all bills. But if that's what they're doing and that's the way it's been and it's not creating a problem, so what? Sometimes when I come in, and I had one case where the library was significantly underfunded because they were only getting between what the town spent on behalf of the library, like for payroll costs, insurance, and other things, and the amount of money that they awarded them directly, it was about 25% or so of the money collected. So if the taxes brought in, let's say $400,000 a year for that library, the municipality was only spending $100,000 of that money on the library. And then the rest of it was put in a reserve fund that ultimately went back to the municipality, to its budget. And when the board members started to understand what was going on and they questioned it, the answer they got was, we can't give that money to the library because then we'll have to raise taxes. Except it's the library's money, and it's the board who determines how the money gets used. It's not up to the town. But I'm not going to go in and say, you have to do this, or you have to change this. If the library board is okay with it, that's not up to me to change it. In that case, the board is not okay with it. And when we did the research and pointed out what's been going on, they brought me in part because they brought in an attorney who happened to be in part because they were very concerned about, we don't have enough money to get the things done, and the town is not providing money like to maintain our building and to take care of different needs that we have, capital needs that we have, and we don't have the money because our budget is so small, and they won't even let us hire staff. They're limiting how many staff members we can hire. Well, the law specifically says under the powers of the board, among the powers of the board are to hire librarians and other staff and set their compensation. That seems to be very clear that the town municipality has no control over who the library board hires and no authority to determine their salaries. But in the place that I was just describing, I went through their ordinances, and in their, every municipality has a salary ordinance that they pass every year, which is fine if they do it for their employees, but that lists the salaries of the library employees, which means the town is setting the salaries for library employees when they have no legal authority to do that. So there's a balance, though, about let's pick our battles and what are we going to fight, because you don't want it to be, in most cases, that the town says, fine, you want your own money, we'll give you all of your money, but then you handle your own payroll, or we're going to charge you for it, and you handle your own insurance, or we're going to charge you, although usually you would contribute something towards insurance, and you can handle whatever, any DPW services that are being provided, that's going to be on you as well. And go find your own insurance. And all benefits are going through us, where you can process your own benefits. Whatever it may be, if you break it down, you have to be very careful, because there could be retribution coming back from the town. And that's a balance, and it's a delicate balance. That's where politics comes in, or political savvy a little bit, and negotiation. But it also means that your outside library attorney has to be educated, or educate themselves about what the dynamics of the politics are of the town, and understand who the players are and what is something that's worth fighting and not. I rely heavily on my board, because as board members, trustees are usually pretty savvy and aware of what's going on in their town, certainly more than I or any other lawyer coming in from the outside would be. And then together we set a strategy and go forward to try to do it. A question: would a library attorney ever work with another specialized attorney in representing a library? If so, what type of scenario might another area of expertise be consulted? When I read this thing, the first thing that came to mind was a trust and estates attorney, somebody who would handle wills, not so much for drafting them, but because libraries sometimes get bequests, meaning they are left as the beneficiary in somebody's will. And usually there's certain requirements, and the library will get a letter from the attorney representing the estate saying you're entitled to this money, and they don't. Library directors know a lot of stuff, but they don't usually know what to do with this. And I know a lot of stuff, but I call my partners and I say, can you take care of this, because you know how to do this and what to do. And then we make sure it's not very complicated once you know what to do, but I could figure the whole thing out, but it's much more efficient just to give it to him, and he knows exactly what to do and gets the whole thing worked out. Another area could be in real estate. If I've had lease situations come up, where, for example, a library is not permitted to pay rent to the municipality for the library space, but it could be that there's space rented from another entity, and that for some reason the library is paying part of the cost for that. When there's a lease involved, I've had it where leases involved for a branch, and so I gave it to one of my partners who does leases. So you're dealing with with a real estate attorney. I've also done things like set up friends organizations and set up library foundations. And while again that's something I can do, it's really dealing a little bit with somebody with corporate expertise, who understands the whole process of completing the form for filing and creating a nonprofit organization, be it a foundation or the friends organization. And so it's another area where you're crossing over, and somebody who's got expertise in library law would not necessarily have that expertise. Again, I've done it. I could do it again, but I also have somebody who does more of it, so I'll work together with them. I can bring in the library aspects of it, but they're bringing in the technical corporate law aspects of it. Another question was, is there a point of contact? Oh, is the point of contact usually the library director or the board of trustees directly? I have contact with both, but it's primarily with the library director. In every case that I can think of, the library director is my primary contact and the person who I speak to the most, and that's the way it should be, because the library director is the administrative chief, the COO of the library, and they're the ones dealing with the problems on a day-to-day basis, and dealing with the employee issues, and they're the ones who to whom the legal questions come. And even many cases when an issue comes before the board, it's funneled to me through the library director. But there are circumstances where I'm dealing with the library board directly, either with the board president, or with another member of the board as designated. And that's usually for specific purposes or specific issues that come up, or sometimes depends upon the nature of it. Like I'm dealing with one of the libraries I've represented for a number of years on some issues with finance dispute with the town, and so I was just on a Zoom call with the board president, another member of the board, and the library director. And so those kind of situations, I'd have interactions with everybody. Obviously, if I'm attending a board meeting, I have interaction and get to know board members a little bit. There's two people that on the call that I recognize because I've been to a couple of meetings for that library's board, and they're on the board. I won't call you out by name, but you know who you are. Thank you. You smiled. Good. So in some cases, I don't know the library board. I've never met any of them, and they've never met me. And my only contact has ever been with the director. And in other cases, I know the boards well. It's a question I think that comes up later about whether the library attorney should attend board of trustees meetings. Of the 26 libraries I said I represent, I think 5 of them, I attend their meetings on a monthly basis. But for all the others, some of them I attend meetings on a periodic basis. If there's an issue where they need something, I'll show up at that meeting, and I'll meet with the board and we'll address whatever issue it is. And then I won't come back until I'm needed again. So maybe that's once or twice a year. I have other boards where I've never met anybody, and some before Zoom where I only ever met the director on the phone. And we communicate by phone or by email. These days through Zoom, we now know what each other look like, and we've seen each other other places, but unless there's a need to go to the board, to board meetings, I don't go. Except again, those boards that for various reasons want to have an attorney there every month. And there is in those circumstances, there generally speaking is some purpose to me being there, and there is a role that I play. But some of that also is a role that sort of carved itself out because I go every month and because the board wanted me there every month. I would never, if the board asked me, do you need to come every month? My answer is no. It's only if the board wants that. And in most cases, again, it's just on an as-needed basis when there's some issue involving the board, or when the board wants. I have one of my libraries just asked me to attend a meeting later this month, or not, I think it's later this month, because the board is having an issue about something specific, and they want their attorney there to explain the legal implications of it. Some boards have a whole lot going on, and so they want the attorney there a lot, but it's not necessary. There was also something in that same question about attorneys attending training, and I don't really understand the question, so I'll answer it the way I interpreted it. And that is, I have provided training for boards. I've done training programs for some of my library boards on things like OPRA, the Open Public Records Act, and the Open Public Meetings Act, and explaining what constitutes a meeting, and to make sure that you understand that if you have a majority of trustees together discussing anything, it's a meeting. It's a public meeting, even if it's not officially a public meeting. I've done training for trustees on things like harassment, because those were issues that the rest of the staff got. So the trustees wanted to be part of that kind of training too. I did training on First Amendment audits and First Amendment rights, free speech things. They are usually, though, it's being done for employees, and I've had trustees come to the staff training rather than request their own individualized training. But I've also had to have it the other way. So it's really a matter of, again, of what the needs are of the board. And I wouldn't just show up at training just to be there. It's usually only if I'm actually doing the training. Another question in the similar vein of should a library attorney have a part when the library creates a strategic plan or a capital plan? I would say, again, it's if the board needs it. If the board, most of the time, strategic plans, I'm not consulted about them. There may be some issue that comes up or question comes up, why the board wants to ask, in which case I'll address the specific questions or review the whole thing just so they want to have an overall legal view. But for the most part, I don't get involved in strategic plans because they don't usually have a legal element to them. And my view is you only use me when you need me. And so I have not had that happen. With capital plan also, you decide how you're spending the money. I'll help you in terms of when the board makes a decision on how to spend to implement those decisions. But and I may help in terms of understanding what a capital plan is and how to reserve the funds for capital planning. But I wouldn't be necessarily involved in developing the plan itself. Unless again there was a specific request. I think I touched on this earlier, a question about should the library attorney review all library policies? I'd say yes, it's usually a good idea, because not only are there legal compliance issues, but there may be issues that come up that are beyond the scope of what the library director really is familiar. The other benefit, though, is there's a lot of repetition between libraries. If you go to the list of policies that your library has and you go to another one, in most cases they're very similar. But I found language in some policies that one library came up with that I thought was really good, a really good way to think about something. And one of them had to do with a code of conduct and sleeping. And instead of just saying no sleeping in the library, because when people read, they fall asleep. I mean, when I'm reading stuff for work, I usually stay awake. But if I sit down with a novel, I'm asleep in 5 minutes. And if I'm sitting in my library and I'm reading my book, I could fall asleep. And I don't think the purpose of the code of conduct is to kick me out because I dozed off in the middle of page 17 or 27 of my novel. It is, though, to take the guy who's stretched out on the couch or who's snoring away or sleeping for hours. That's the person who's a problem. So we have it, and there was specific phraseology that, of course, fell out of my head before I said it, of how one library worded it. And I said, "Oh, this is really good." And now all of the libraries I suggested it. I said, because everybody else I showed it to said, "Oh, yeah, that's a good way to say it." And so there are other not legal per se reasons why it's advantageous to have your library attorney review the policies. There are sometimes just practical and I just know what a lot of different libraries are doing, and you can share those experiences. Another question, do you participate in industry or association events? If so, which ones and what topics have you presented? Well, I speak for Buckles sometimes, and I talk about attorneys and library attorneys. All right, that was a little bad joke, but obviously I'm doing that right now. So yeah, for me, I can't speak for other attorneys, but obviously I speak for and have spoken at Buckles. I've spoken at NJLA a bunch of times. NJLA's conference is coming up at the end of the month, and I'm there. I'm on a panel talking about book sanctuaries or library sanctuaries. I've spoken also at an ABA conference. And also for the state library, because what happens is because I've represented a bunch of libraries, I know a bunch of directors. I mean, truthfully, the reason I'm speaking here tonight is because one of the chairs of one of the committees, or at least a member of one of the committees who's sponsoring it, happens to be a library I represent. The director is a very nice person, and he emailed me and said, "We're doing these. Would you be interested in speaking?" And so that's why I'm here. And generally speaking, not generally, that's typically how I get, because I know somebody or they know me, and I get invited to speak. And so I've spoken about book bans and about First Amendment audits. I've spoken about funding. I've spoken about harassment, about free speech. I did a topic on civil service and the implications of civil service. And there's probably and obviously about the role of attorneys representing libraries, either as library labor counsel or as general library counsel. And there may be some others as well. But so yes, I do that, and that's also a fun aspect of my job. You know, libraries is not such a big industry, so all of the library directors who are involved, they all know each other. It makes it kind of interesting because I'll be telling a story. I'll never identify the client I'm talking about, but I'll be giving a scenario to one and helping them deal with their issue. And they say, "Oh yeah, that happened and they'll identify the library." And I'm saying, I won't acknowledge that you're right. I'll say, "Why do you say that?" And they'll say, "Oh, because Susan, the director of that library, is a good friend. And so she told me," so they know all about it. And it's good because they know each other, and so they're sharing information. Sometimes it makes it hard to be a little bit as discreet or confidential as we would like, but we do our best. I'm going to skip that question. All right. That I think covers all of the general kind of questions. Where can we find a list of attorneys that specialize in library law? I would say look at the panel of presenters for tonight. That's where you'll find the best. All right, that wasn't that funny. I don't know. I don't know where you would find that list, but probably if you call my office, no, that's a cheap shot. NJLA could probably give you a list of other attorneys, because I believe once I was, ironically, the library for the town where I live sent me a letter at work, and that they got my name from NJLA as an attorney who represents libraries, and invited me to apply. And I applied, and I had 2 interviews, and then they ended up hiring me. And notably, since it is the town where I live, it ties back to what I was saying earlier. They specifically asked me the question, given the fact that I'm a citizen and taxpayer in my town, if a conflict came up between the town and the library, is that going to be a conflict for me? And I said, absolutely not, because if it's something where the library is not right, I'm going to tell you it's not right, and I'm not going to discourage you from pursuing it. But if the library is right and the town's wrong, I'm 100% going to advocate against my own town, because the town's wrong and they should be corrected and doing the right thing. So it was not a conflict, and I've been blessed to represent this library for 8 years or something. I don't know exactly how long, but it started from a list of names from NJLA. So the other place, actually, I should have thought of this. Buckles is a very good place, because a lot of times I get contacted by a library director saying, "Am I interested in applying?" They got my name through Buckles, or Maine, which is the Buckles that's based in Morris County, and then there's 2 or 3 others similar in different, one based in Middlesex, one in Passaic County. And so the directors, as I said, they all talk to each other, so that's a logical place. But if you're here, you're probably part of Buckles, so you could speak to, the director would talk to other directors in Buckles. And then get my name. That part was a joke. All right. We're about 2/3 through the evening. So there were a bunch of questions that talked about book challenges and First Amendment audits. And I touched on it a couple of times, but I want to spend a little time on it now. What I should have said at the very beginning, and I didn't, is that I am not giving legal advice to anybody when I speak here tonight. I don't represent, and well, I represent a few of you, but I'm not here giving legal advice. I'm just here giving general information. So nobody should interpret this as legal advice. And you should go back, if there's something I said, you should go back and not rely on it without conferring with your own attorney. And if they disagree, then they're probably not right. But I know you're all laughing, but I can't see you or hear you, but I know you're laughing. So with that, because there were a couple of legal questions, and so I'm trying to walk that line. The first question in the area is, how might a library attorney respond to book challenges? What might that person advise the library staff to respond? Well, I don't respond to book challenges. The library does, but I can help you do that. And the first place you start is the policy. I said something earlier about collection development policies. Having a good, tight collection development policy is vitally important, because there you can limit things like the number of challenges and the way challenges are done, and who can submit a challenge. There's a lot of procedural things that we put in, I wouldn't say as roadblocks, but certainly as a means of ensuring that the people who are questioning or challenging a book have some basis for doing it, and it's not just somebody from Kansas who decides to challenge. I just picked that randomly, not for any particular reason, but who's deciding to challenge, submit book challenges all over the country. So I would limit it to like card holders or residents or something along those lines. And then I would just make sure that you're consistent and that you follow your procedure and you have it intact. Has book banning issue caused libraries to consider increasing their legal coverage full time? I would say no. I don't think I have not met a library yet that needs full-time legal staff. Even the ones where I spend a lot of time for them, they don't need me full-time. Nobody does. No, I don't. There may be libraries that do, but I haven't encountered one in New Jersey. But does it mean that there's more need for a library attorney based on the increase of book challenges? For that, I would say yes, because there's challenges, there's First Amendment audits that we'll talk about in a minute. And there's a lot of legal issues that come with it. Some of it I can help in terms of revising the policy and how to think about the policy. Some of it is, what are the legal considerations for First Amendment audits and First Amendment rights, and what do people have the right to do, and what does the library have the right to do, and what does the law say? I'm familiar with that because I get asked the question a lot, and because I've researched it and spoken on it, and so I'm quite familiar. And so it's very helpful and useful to have that. It may be that your director is very well conversed in the subject and equipped, and you don't need a lawyer to do it, and that could be fine too. I just think it's been helpful for my clients to have it. Next question is, do you know if there is an increase in the amount of book challenges overall, or challenges to property libraries have purchased, etc.? For here, I pulled up some statistics, and these are from 2002, so I don't have the 2003 statistics. They may be out, but I don't have them right in front of me. But this is helpful enough, I think. The American Library Association publishes statistics about book banning each year, and let me just give me 1 second to Okay, so for 2002, there were 1,269 attempts to ban or restrict library materials in 2002. And there were 2,571 unique book titles that were targeted. The difference between those numbers is because those libraries allowed more than one book to be included in the same challenge. So if you can challenge multiple books at the same time, you could do it. I remember reading about in Florida, some woman was challenging a series by Patterson, by James Patterson. And she said she hadn't read the books, but she was still challenging the whole series. And so the series has, I think, like 7 or 8 books in it. Of course, the name just flew out of my head, but it's a like a young adult series. I'm familiar with it because I read it with my kids when they were younger. I don't know what basis she has, but she doesn't know either because she never read the books, but she was still challenging them. And she was challenging a lot at once. How this compares, let me just do this. Okay, now I can see this better. And okay, now I can see it better. For the number of attempts, in 2003, nationally there were 458, and 2012 there were 464, but by 2020 was a low year because of COVID. 2021 though, there were 729. So from 2012, from 2003 to 2012, it didn't increase barely at all. From 2012 to 2021, it increased by close, not quite double, but say by 80%. And then from 2021 to 2022, we went from 2,729 to 1,269. Likewise, in terms of the number of titles, in 2000, there were 378 titles challenged. 2005 and 2010, they were both in the mid 200s. 2021, it jumped to 1,858. And again, as I said, in 2002, it's 2022, excuse me, it was almost 2,600 unique titles. The frequency of titles, again, this is 2002 data, but the book challenges filed in New Jersey in 2002, at least, there were 13 book challenges and 28 titles challenged. I am positive that that number is much higher for 2023 and 24, just based on how many challenges I've heard about from clients. And again, representing 25 municipal libraries, or 24 municipal libraries, represents a little more than 10% of libraries in the state, municipal libraries in the state. So, and I'm sure I've heard about close to that number just on their own. That represented 28 unique titles that were being challenged. And the number one most challenged title is a book called Genderqueer, a Memoir. I have stats on other states, but I don't know that that's as important. Another stat that I saw was about who initiates the challenge. And again, from 2022, and this is nationally, but 30% of challenges were initiated by parents, 28 by patrons, 17 by political or religious groups, 15% by the board or the administration, 3% by teachers or librarians, 3% by elected officials. One of the reasons for that numbers is these challenges include challenges to books in school libraries as well as public libraries. And the breakdown for 2002 was that challengers made 10% were just in schools, 41% were school libraries, and 48 were public libraries. So it's a very close breakdown between school libraries and public libraries, where the challenges are going. And but clearly the numbers are increasing, and it's only going to get, I think, worse before it gets better. I should say that I have a very strong opinion. Politically, I don't, in my job, I don't talk politics, almost never. I might talk about political ramifications, but I don't express political viewpoints, except about this issue, because this issue, one, I believe in it very strongly, and two, it obviously affects my work. And I'm very much opposed to book bans, and very much supportive of free access to reading materials. There's a movement that's called the Book Sanctuary Movement. And what it means is that the library, and sometimes the municipality, the library board passes a resolution that says our library is a safe space and people can come into our library and they can read safely without any risk of limitation or any judgment. And it's very much encouraging it. And I know off the top of my head, I know Millburn Library is represented tonight because I can see the director, and that they are a book sanctuary library. I know Hoboken is a book sanctuary library. That was actually Hoboken, I believe, was the first one in New Jersey that adopted. And the library board, once they adopted it, they spoke to the town, and the city of Hoboken adopted a similar resolution, making Hoboken a sanctuary, book sanctuary city. It's basically a strong statement favoring First Amendment rights to access to books, and opposing book bans. Now, it doesn't mean that they don't have policies that would allow people to challenge books for a reason, but they're still making it a safe space for the book bans. It's a subject that I'm speaking about. Actually, that's the topic. I'm on a panel for NJLA in 2 weeks. If you want more information on it, I would say I'm gonna out him and just say you could contact the director of Millburn Public Library or of Hoboken Public Library, or just do a quick check. And because again, I think there's, Mike, do you know how many libraries currently in New Jersey?
I don't know the exact number. It might be 8, 10, or a dozen.
All right, that's what I was thinking. So
it's growing.
Yeah, it's definitely growing. Thank you. Sorry to out you, but you're here.
I heard
so-
19 somewhere. I don't, I think it was at a Buckles meeting or something. That there were
Okay.
19. So
All
maybe
right.
more than just the 9. Yeah.
All right, so it's somewhere, it's less than 20, but it's something that's
Yes.
clearly growing. And it's a movement here. I don't know that it's going to go across the whole country. But I know that on our panel, there's a library director from Kentucky. Yeah, I'm pretty sure it's from Kentucky, which has some connection to the Hoboken Public Library. It's like a sister library or something. But they also, I think he's director of a county library system, and they also adopted a book sanctuary resolution. Okay, I want to talk about First Amendment audits just briefly, and then we'll open it up to see if there's any other questions. Oh, there's a question that I saw that popped up. What if a library is a sanctuary, but the city rejects the sanctuary city? The book sanctuary, as the library is the book sanctuary, means within the library walls. If the city adopts it, that means throughout the whole city. It doesn't, the fact that the city council doesn't adopt it doesn't undermine what happens inside the library. It just doesn't extend it beyond the library. Okay. What a First Amendment audit is, or the way it works, is that someone comes into the library with a camera or their phone, and they're videotaping as they walk around the library. And the ostensive reason for doing it, or stated reason for doing it, is they're monitoring First Amendment compliance and making sure that nobody's violating people's First Amendment rights. It started with police officers where they would do that, and we've all seen videos of that, and we know why. And then it branched to other divisions of government, other municipal offices, but then they hit on libraries, and libraries have been a target. The irony of it is that libraries are in the business of promoting and protecting First Amendment rights, and so it's the dumbest place to be checking for First Amendment violations or compliance. But the practical reason why they do it, in my experience, what they're trying to do is to upset people, library staff members or others in the library who are being recorded and are not comfortable with it, getting them to act out and then posting it online on YouTube or on some other station and then monetizing it. So they're using it as a way to make money by embarrassing library staff members. I have seen a couple of them. I don't look at them usually because I don't want them to get hits, which helps them to further monetize and therefore encourages them to keep doing it. But where somebody lost their cool and got very frustrated, and the person filming obviously was pushing this person's buttons and doing things to get the person agitated, and it worked, and so he put on a show. So first, it's important to understand that legally people have the right to record in a library. Now, you could put some restrictions on that, but the library itself can't stop somebody from walking around and recording in the library. If they're disturbing someone, certainly any member of the public, so any patron who doesn't want to be recorded can say to the auditor, I don't want to be recorded, stop recording. And if they're bothering them, then if you have your code of conduct policy in place, they're interfering with somebody else's use of the library, and therefore they're in violation of the code and they have to move on. Don't necessarily have to leave, but at least move on and film someplace else. There are ways to insulate from children, but children just sitting out in the library are no more protected than anybody else. Much like if they're walking on the street and somebody could film them the same way. There are ways then we do it in terms of the way we write policies to limit that and protect kids, but they still have the right. For library staff, as a public employee, they have the right to record you doing your job. And as long as they're not interfering or disrupting with the person's ability to do the job. And a disruption doesn't mean that the library employee is uncomfortable or embarrassed to be recorded or doesn't want to be recorded and finds it annoying. It means that the person is doing something to obstruct that person's ability to do their job. So if they just come in and if I'm working at a circulation desk or at a reference desk and somebody comes up and they're recording me and asking me questions, which are legitimate questions to ask, I just have to answer the question and I could be filmed and I could be put on YouTube or otherwise. And so again, this isn't legal advice, but the general recommendation from anybody involved in this is be boring. Truthfully, doing the job that people do in libraries, unless you're doing a program, it's not that exciting to watch. Neither is my job. Most jobs are not that exciting to watch when people are doing their job. And so the recommendation to staff is just do your job and don't make it exciting for the person, because if it's not exciting, they have nothing to post because no one's going to watch it. I'm just looking at two comments. One said as of, okay. So somebody's commenting about the fact that can everybody see the comments? So I should not be even talking about it. All right. So you see that this gentleman posted, I think it's this person posted, bottom line, didn't give them what they intended for clicks, and so they wandered away. And that's really the strongest way to respond is to be boring and don't make it exciting. I saw that that Mike posted that as of May 2024, there are 22 libraries or library systems and 4 municipalities that are book sanctuaries in New Jersey. Okay, we have only like 3 minutes left, and there's at least one other question I didn't get to, so I'm going to go to that. And this is a question from earlier. Does the rule about library not paying for municipal space apply to municipal spaces outside of the library? For example, our library under construction, which will limit meeting spaces. I'm not sure I totally understand it, but let me say it this way. The rule says that a library cannot pay rent to the host, to a municipality for their space. So the fact that the title to the library building is in the name of the municipality, they can't charge the library board rent to be occupy that space, because the law says that the municipality has to provide a library space if they're going to establish a library in the town. If there's other places where you have to meet elsewhere, because the library is under construction and closed, if it's within the municipality and municipal property, I would say that you should not pay for rent for the same reason. But if you need to go to a VFW hall or something else that's owned by a private entity, then and pay rent there, that would be permissible. Okay, it's 8:28 or 8:29. Tom, I'm going to turn it over to you unless there's more questions that I didn't see.
I don't see any more questions. So I want to just thank you very much, Douglas, for a very informative and educational meeting. A lot of great material was covered, and I trust all of you had a great feeling about it as I did. Just a couple of quick administrative things before we go. Please complete the evaluation forms that you've received. I make this pitch every chance I get. We really pay attention to the evaluations. We especially want to know what you folks want us to present to you in the future. Follows up to this meeting, other things that have to do with capital planning, budgeting, anything that you would like us to talk about or like us to have either a roundtable, or a program on any of those subjects, please put them in the comments on the evaluation forms. We take them very seriously. Because we want to provide the programs and roundtables to you that you want to see. So please complete those. You will be receiving certificates in about 3 weeks for your participation in this program. They will come from the Buckles office. Also, speaking of roundtables, I would like to advertise there will be invitations sent out for our next roundtable tomorrow. The next roundtable is being held on June 5th. It'll be the 3 R's of being a trustee. Your role is, we will be discussing, or you will be asking you to discuss your role as a trustee, your recruiting efforts to get new trustees, and what you do to retain existing trustees. We consider these very important subjects, and this is a program that you asked, roundtable you asked us to put on. So we're going to be doing that on June 5th. And as I said, you'll be getting invitations starting, be sent out tomorrow. So
I'm just going to echo one thing Tom said. I haven't seen the evaluations, but I assume there's some evaluation of the presenter. And if so, I'm very interested, because it's very hard when I'm in front of a group of people and I can see you and I can see your expressions, then I know how things are going and how it's being received. But for the most part, other than a couple of faces who have stayed visible, I'm talking to, blank screens or names. And so whatever feedback you could offer to me as a presenter, I'd greatly appreciate. I also take it very seriously, and it'll help me to be better. I've been speaking to groups for years, but again, it was always before COVID. I wasn't doing it on Zoom. I think Zoom didn't exist, or certainly not for most of us. So it's a different kind of experience. So whatever, any feedback that you'd like to offer, I'm happy to receive. And I thank you very much for your time and attention.
Douglas, we will be sure to get those to you so that you can see what the folks had to say. It's all been very good, and I'm seeing all the thank yous and excellent presentations coming up in the chat room. So I think we have another good program. We always do, well, especially with folks like yourself, giving such excellent information. That's all I have at this point. I thank you all for coming on behalf of both the Trustee Development Committee and the LAMP Committee. We are again very pleased that you came, and glad. We think it was a wonderful presentation. Everybody have a wonderful Memorial Day as it comes up soon, and the summer will be upon us. And you'll be hearing from us about another program which will be coming up in the fall. So thank you again. Thank you, Douglas, and everybody have a wonderful day and a wonderful night.
Bye, Tom.
Thank you.